Missouri Medical Marijuana Draft Rules for the Cultivation Facility. This is the fourth video in our reviews of the draft rules proposed by Department of Health and Senior Services for medical marijuana. I've set up a playlist with the draft rule videos we've produced. Please take a look at that. My name is Patrick Nolan. I'm an attorney licensed in the state of Missouri. This is Pat Talks Law. This video covers the draft rules for the cultivation facility. The rule is 19 CSR 30-95.050. First, the rule and my comments on it. 1. Cultivation facility licenses. A. The number of cultivation facility licenses will be limited to 60 unless the department determines the limit must be increased in order to meet the demand for medical marijuana by qualifying patients. B. A facility license will be issued for a single facility in a single location. Combinations of licenses at the same location must be approved pursuant to 19 CSR 30-95.040, paragraph 3C. Section 2. Cultivation facility requirements. In addition to the requirements for cultivation facilities in 19 CSR 30-95.040, cultivation facilities shall also comply with the following. A. Cultivation facilities may cultivate medical marijuana in indoor, outdoor, or greenhouse facilities, or some combination of the three. Each indoor facility using artificial light will be limited to no more than 30,000 square feet of flowering plant canopy space. I'm having a hard time reading this. 2. Each outdoor facility utilizing natural lighting will be limited to no more than 2,800 flowering plants. 3. Each greenhouse facility using a combination of natural and artificial lighting will be limited to, at the election of the licensee, no more than 2,800 plants, flowering plants, or no more than 30,000 square feet of flowering plant canopy space. 4. If a cultivation facility is operating with multiple cultivation licenses in the same location, the size limitations of the facility will be multiplied by the number of licenses. Paragraph B. Facilities may not use a pesticide in the cultivation of marijuana if the pesticide appears on the list of prohibited pesticides published on the department's website for medical marijuana. The facility must keep records by month and by batch of all pesticides, herbicides, fertilizers, and other agricultural chemicals applied to marijuana plants and growing medium during production and processing at its facility for at least 5 years. Paragraph C. Facilities must develop, implement, and maintain an odor control plan, which shall address odor mitigation practices, including but not limited to engineering controls, such as system design and operational processes, which shall be reviewed and certified by a professional engineer or a certified industrial hygienist as sufficient to effectively mitigate odors for all odor sources. D. Cultivation facilities must ensure all facility employees are trained in at least the following. 1. The use of security measures and controls that have been adopted by the facility for the prevention of diversion, inversion, theft, or loss of marijuana. 2. Procedures for responding to an emergency, including severe weather, fire, natural disasters, and unauthorized intrusions. 3. Standards for maintaining the confidentiality of information related to the medical use of marijuana, including, but not limited to, compliance with Health Insurance Portability and Accountability Act, HIPAA. 4. The methods of cultivation used by the facility, and 5. The facility's safety and sanitation procedures. Section E. A cultivator shall ensure that a consistent supply of medical marijuana is available to the market by timing its harvest such that no more than 120 days elapse between harvests. You've got to stage your grows. F. Cultivation facilities shall not transfer medical marijuana from the facility except to a testing facility until the medical marijuana has been tested by a testing facility. That's according to provisions of 19 CSR 30-95.070. And the cultivation facility has received verification from the testing facility that the medical marijuana has passed all required testing. Okay, there are a few minor changes in this draft rule from what we were expecting. First, the rule limits the number of cultivation facilities to 60. We were expecting 61 based on population numbers, but it appears that DHSS counts differently and has that set at 60. Also, we can now grow indoors, outdoors, or in a greenhouse. Indoors, you have your 30,000 square feet. Outdoors, 2,800 plants. In a greenhouse, you have to pick between the two. Now, where this is getting really interesting is that you can have up to 3 cultivation licenses. And this draft rule allows for co-housing of your licensed cultivation facilities, which means under one roof, if you have 3 licenses, you can have up to 90,000 square feet of flowering plant canopy space, or 8,400 flowering plants. I see consolidation in cultivation license holders or rented subcontracted growing facilities becoming possible. Now, the odor control requirement, ridiculous. But we are requiring odor control plans on cultivation facilities. It boggles the mind. I expect this rule to be added to before it is implemented. But remember that as short as it is, it must be taken alongside the draft rules for marijuana facilities generally and the draft rule for general provisions. Additionally, you should expect that there's going to be some environmental or other regulatory inputs on the facilities before they are completed. That's going to impact profitability and timing. Please check out my other videos on medical marijuana draft rules and other videos on other general legal content. If you are in Missouri and are either a landlord or a tenant and you're concerned about your rights as medical marijuana comes online, please go to pattalkslaw.com and pick up a copy of our lease addendums for only $25. This addendum should help protect your rights to either use it or to prohibit it in your property. Please remember to like, subscribe, and hit the alert button. Thanks for watching.